The Supreme Court on Tuesday will hear arguments for and against President Biden's student debt cancellation plan. Last August, Mr. Biden announced $10,000 in forgiveness for people making below a certain income level and an additional $10,000 for Pell Grant recipients. 6 states and 2 individual debt holders are now suing the administration. The court's decision could affect some 43 million Americans, 20 million of whom could see their debt wiped clean if the plan goes forward. Joining us now is Jonathan Adler. He's a professor at the Case Western Reserve University School of Law. Jonathan, let's just talk about the basics of this case. What is the central issue of this case?
The central issue in this case is whether or not, when Congress enacted something called the HEROES Act, it gave the executive branch the authority to wipe out principal for student loans the way the administration is doing here. So that the court wants to know is whether or not Congress gave this power to the executive branch. And then there's a procedural question that the court's probably going to spend a lot of time on about whether or not the groups and people challenging this action have the standing to bring this case before the courts.
Excellent. All right. We're going to put the standing question to the side, make it stand to the side, and back on the narrow question of this legislation. Do you see it as an issue of whether the president has acted or the executive branch is acting within the confines of this specific legislation? Or do you see a larger story at play here, which is the court's reluctance to let the executive branch and the agencies assert too much power on their own? So a broader view about executive power.
It's both. The Supreme Court in recent years has made clear that power to do these sorts of things initially comes from Congress. And so if the executive branch wants to do something like erase student loans or create a new regulatory program, it has to identify where Congress passed a law that gave the executive branch that authority. So in recent years, with regard to COVID measures, with regard to environmental measures, the majority of the court has made clear that they look very carefully to see whether or not this power has been given. In this particular case, there is a question about the language of the statute, but you're certainly correct that there is this broader theme we have seen in recent years where the court is saying that Congress has to speak clearly when it's giving the executive branch really broad authority.
Now let's bring in, Jonathan, that question of standing. What does that mean in this specific case, and how might that affect the outcome?
Sure. So the basic idea is that when someone wants to file a lawsuit challenging the government, they have to identify how what the government did actually affects them. So if the government is prosecuting you or regulating you or doing something to you directly, standing isn't an issue. It becomes an issue when the government is doing something more broadly that doesn't have a direct effect. So here, some individuals who did not get loan relief, some states that claim their interests are affected by this action are suing. And the question is whether or not they suffered the sort of injury that can justify a court's jurisdiction. And this is a tricky question, and it's a question that I think the court will probably spend the lion's share of the oral argument time tomorrow focusing on, both because it's a difficult area of law and because it's not clear that all of the parties challenging these actions can demonstrate that they have suffered an injury that allows them to bring this sort of case to court.
And so if it's determined that that nobody has standing, then the court punts and moves on. In other words, these questions of executive power in Congress and whether it fits in the HEROES Act, those all don't get adjudicated.
Exactly. The idea is that there are some issues that may be very important, but that ultimately have to be resolved within the political process. And so in this case, one of the states, Missouri, has created an entity called MOHELA, which some viewers probably have student loans that are managed by MOHELA. Missouri claims that this state entity is sufficiently affected by this action that Missouri has standing. That's the strongest argument for standing here. And if that argument fails, it effectively means that this is a fight between the executive branch and Congress, and the courts will stay out of it.
And we know how those get resolved recently. Let me ask you one final question, Jonathan, which is that 6 Republican-led states have sued in one of these cases. Is this another instance in your mind of the party that doesn't hold the White House uses the court system to check that White House's power, which both Democrats and Republicans have done, or do you see something new in the approach being used in this case?
Well, we've seen a trend now for about the last 15 to 20 years where attorneys general, in particular, of the opposite political party challenge the existing administration with some regularity. So this began in the late Bush administration. We saw it throughout the Obama administration. We saw it throughout the Trump administration. And it's becoming, it's accelerating. States are becoming more aggressive in using the courts to wage political battles against a president of the opposite party. And it's been going back and forth now for, again, about 15 years. And I certainly think at some point the court will reconsider whether or not it's made it too easy for states to file these sorts of suits, because the courts really shouldn't be the place where all of these big political questions are resolved.
Exactly. Professor Jonathan Adler, thank you so much for being with us.
Thank you.